The Biden administration launched a whole-of-government effort to identify, intimidate, bankrupt, and jail the people and institutions that made up President Trump's political world. It reached President Trump. It reached his lawyers. It reached former officials. It reached Republican organizations. A Biden White House official reacts to Fani Willis by saying, "Fani Willis is an icon. I can't help but to stand." Let me say that again. The Biden White House was gushing over Fani Willis being an icon. Fani Willis's office in Georgia was pursuing its own prosecution. Her team coordinated with the Biden White House on executive privilege issues. They tried to bankrupt President Trump. They tried to deplatform and delegitimize him. They tried to imprison him. Who authorized this? How far did it go? Today, the Senate Judiciary Committee meets to examine Operation Arctic Frost and the broader campaign of lawfare against President Trump, his allies, his lawyers, Republican organizations, members of Congress, and the American right. This hearing is not about relitigating the 2020 election, and it's not about saying anyone is above the law, and it's not about asking for special treatment for any political figure. It's about something more basic and far more dangerous, whether the coercive powers of the federal government were used as a political weapon against the opposition. In this country, law enforcement is supposed to investigate crimes. It's not supposed to investigate political movements. It's not supposed to map the opposition. It's not supposed to use subpoenas, search warrants, non-disclosure orders, telecom records, bank records, device searches, and secrecy tools to build a profile of one side of American politics. But that is what the evidence increasingly suggests happened here. The Biden administration was not just investigating a crime. They were seeking to dismantle a political movement. The American people deserve to know what Arctic Frost really was. Arctic Frost, in the effort to take down the American right, was broader, darker, and far more dangerous than anything we've seen in modern political history. The Biden administration launched a whole-of-government effort to identify, intimidate, bankrupt, and jail the people and institutions that made up President Trump's political world. It looks like a dragnet, a fishing expedition. It reached President Trump. It reached his lawyers. It reached former officials. It reached Republican organizations. It reached conservative institutions. It reached communications records. It reached members of Congress. It reached people and groups whose real offense appears to have been associating with President Trump and the American right. And today, as part of this hearing, we're releasing new documents that make this even more clear. One set of documents shows Jack Smith's prosecutors discussing how to get around speech and debate protections as they considered how to obtain information involving Republican members of Congress. These are not abstract constitutional questions. The speech and debate clause exists to protect the independence of the legislative branch from executive intimidation. Yet here we have prosecutors looking at Republican members and asking, in effect, how close they can get. In those messages, prosecutors discussed cloud data, phone records, notice, and whether they could, quote, get the cloud, not notify, and do the search without consulting the member, end quote. That should alarm every member of this body, regardless of party, and also the American people. Another set of documents shows communications between the Biden White House and Fani Willis's team in Georgia. Those records show Fulton County prosecutors reaching out to the White House counsel's office as they sought to interview former executive office of the president officials and the White House facilitating the executive privilege process. And in one remarkable email, a Biden White House official reacts to Fani Willis by saying, "Fani Willis is an icon. I can't help but to stand." Let me say that again. The Biden White House was gushing over Fani Willis being an icon. That is the language of political fandom. I wonder if the Biden officials found her embezzlement scheme iconic. I wonder if they stand Fani's removal and disqualification from the Georgia election case without any criminal conviction. So when we talk about coordination, we're not speaking in hypotheticals. We're talking about documents the committee is releasing today. We're talking about records. We're talking about the machinery of government turned in one direction. Look at the timeline. the Biden White House helped facilitate access to President Trump and Vice President Pence's government phones. White House Deputy Counsel Jonathan Su personally assisted the FBI in obtaining access to those phones as Arctic frost was heating up. When the investigation expanded, it merged with the DOJ Inspector General's work. It swept in lawyers, former officials, devices, email accounts, iCloud accounts, the political organizations. It became the foundation for Jack Smith's case. At the same time, Fani Willis's office in Georgia was pursuing its own prosecution. Her team coordinated with the Biden White House on executive privilege issues. Willis's lover and taxpayer-funded outside counsel, Nathan Wade, billed Fulton County for an interview with D.C. White House, quote, interview with D.C. White House, end quote, on November 18th, 2022, the same day Jack Smith was appointed special counsel. Then, within weeks of Jack Smith's appointment and the White House contact with Wade, Matthew Colangelo, who was the #3 top official in the Biden Justice Department, went to the Manhattan District Attorney's Office, where Alvin Bragg brought a case against President Trump, and it was revived. Federal investigators, a special counsel, the Biden White House, Fani Willis in Georgia, Alvin Bragg in New York, Matthew Colangelo deployed from DOJ to Manhattan. Jonathan Su helping facilitate access to Trump world records, Jack Smith prosecutors discussing how to work around speech or debate protections. Luckily, the American people were wise enough to see this for what it was, a coordinated campaign of lawfare against President Trump and the American right. They tried to bankrupt President Trump. They tried to deplatform and delegitimize him. They tried to imprison him. They tried to throw him off the ballot. And after years of demonizing him, there were 2 assassination attempts against him. The American people sat in the jury box and rendered their own verdict on November 2024. It was an acquittal. But the effort to get Trump was not simply an investigation of alleged conduct. It was an effort to map a movement. And that's what makes Arctic frost so dangerous. The Democrats knew they wouldn't get a criminal conviction on Turning Point USA, Republican Attorneys General Association, and America First Legal. But convictions weren't the point. The process was the punishment. The subpoena was the punishment. The search warrant was the punishment. The non-disclosure order was the punishment. The legal bill was the punishment. The professional threat was the punishment. The years of uncertainty were the punishment. The ideological capture state, bar, going after your ability to practice in the legal profession, was the punishment. The government does not have to convict you to ruin you. It can drag you through years of legal process, force you to hire lawyers, threaten your livelihood, expose your associations, and send a warning to everyone around you. Represent the wrong client, work on the wrong case, donate to the wrong organization, serve the wrong president, and you're next. This is not equal justice under the law. That is political discipline by legal process. And to be clear, this hearing is not about saying anyone is above the law, but law enforcement is supposed to investigate crimes. It is not supposed to investigate political identities. It is not supposed to treat opposition lawyers, donors, staff, advocates, elected officials, and institutions as a target set. A campaign can do opposition research. A party can build a political file. But when the FBI and the Department of Justice do it with subpoenas, gag orders, device searches, telecom records, bank records, and secrecy tools, that isn't politics. That's state power. And when state power is aimed at one political movement, it becomes political surveillance by legal process. A republic cannot survive legal attrition against the opposition. That is not the rule of law. That is regime protection. So today, this committee will ask basic questions. Who authorized this? How far did it go? Why were these records sought? Why were there secrecy orders used? Why were prosecutors discussing ways around speech or debate protections? Why was the Biden White House communicating with Fani Willis's team? What was Nathan Wade doing at the White House the same day Jack Smith was appointed? Why did senior Biden DOJ officials end up helping lead the Manhattan case? And what must Congress do to ensure that this never happens again? That argument is not only wrong, it's dangerous. There is a fundamental difference between weaponizing the government and holding the weaponizers accountable. Weaponizing government means using subpoenas, search warrants, secrecy orders, prosecutions, and federal power to punish your political opponents. Holding the weaponizers accountable means exposing that abuse, demanding answers, and restoring the rule of law. Weaponizing government means turning law enforcement into a political weapon. Oversight means Congress doing its constitutional duty to make sure that that weapon is never aimed at the American people again. That is why this hearing matters. Because if the government can secretly map, burden, and punish the political opposition, then political opposition in America is tolerated only until it becomes effective. And if Congress cannot investigate that, then oversight is dead, accountability is dead, and the weaponizers win. And we will not let that happen. I want to ask you, you referenced the you being targeted not just by Arctic frost, but in Fulton County, multiple proceedings. In that proceeding in Fulton County specifically, you and your lawyers sought documents, communications, including Nathan Wade's billing entries for his conference with White House counsel, the interview with D.C. White House, but Judge McAfee placed certain materials reviewed in camera under seal. Why are those, could you explain to the committee, why are those sealed communications so important?
Well, thank you for that question. Look, we don't know what's in the communications until we see them. We obviously called for them. We think we have a right to show them, and we think part of the correspondence showed that the Justice Department did not give what's called TUI authorizations to Fani Willis so that she could put witnesses from the Justice Department in front of the grand jury. And we posed the obvious question of, if she can't produce any witnesses from the Justice Department against me, then how could she possibly proceed with her case? We think the judge erred in not recognizing that that was a serious Brady issue, but he decided after he looked at the documents to put them under seal. I think this body, and I think the Justice Department, could get access to those materials.
In kind of zooming out then, beyond just what you endured through all of this, you've described Arctic frost as part of a coordinated effort, not just to simply punish individuals, but destroy the infrastructure around President Trump and a movement, really. Explain what you mean by that.
Sure. Maybe it's easiest actually to start with the weaponization of the bar complaint process, which some call part of Lawfare, others call Barfare now. The 65 Project was created by David Brock, who is a super leftist Democrat activist. And he specifically admitted in a scoop story he gave to Axios with Jonathan Swan, who's now at the New York Times, that his whole purpose was to make conservative lawyers adjacent or who represented President Trump, toxic in their legal communities so that they could not get jobs and so that their reputations would be destroyed so that no one else would represent the conservative movement. That's a complete act of destruction aimed at our adversary system. We can't have a system in which only one party can have election lawyers. David Boies and Professor Lawrence Tribe in Bush v. Gore in 2000, they faced no ethical consequences, but somehow if you're a Republican lawyer, if you're a John Eastman or a Rudy Giuliani or you're a me, you are treated to an entirely different standard, and it's designed to try to shame.
Dr. Epstein, I want to ask you, you've reviewed the documents, and this is just a myriad, this is a web, right? You've got DOJ, you've got DOJ, OIG, NARA, Jack Smith, the Biden White House, Fulton County, Manhattan. You've got all these actors. Does this look like some isolated law enforcement effort? Does this look like a coordinated attempt to take down a chief political rival and anybody that had any support for him?
No, I think you're absolutely right. This was clearly not something where the starting philosophy was, let's go through a very orderly process. I mean, the fact that the National Archives was consulting with the White House counsel's office on how to get documents to the FBI and debating whether they should go through the clear path of communicating with the president's counsel and getting consent, or to concoct statutes in a way that allowed them to not do that. The fact that you had coordination between Bragg's office and the Department of Justice, which when the House of Representatives asked that question to the Attorney General, he denied it. But the existence of responsive records clearly indicates that there were communications. I think this raises the significant risk that this was not a sober investigative process. It was very much tainted by political interests.
And you also raised the possibility that this just wasn't a bad judgment or even just political bias, but that this was potentially unlawful conduct, correct? Could a conspiracy against rights be one of those kind of charges under federal law that could be brought?
Under Section 241, absolutely. And, I think this committee has done very good work on investigating that. I think, as you pointed out, the process is the punishment. And when you have very aggressive bureaucrats who want to coordinate with prosecutors in a way that doesn't follow the process, doesn't follow fair procedures, that raises the significant risk of conspiracy against